here. Uh, okay. Welcome everybody. Today we have Frank P. Woods joining us. Welcome, Frank.
Hey Jim, how you feeling tonight?
Not bad. How about you, brother?
Well, some ups and downs like you in the end, but I think we're doing okay.
Yeah.
And I know it took a while for both of us to get our schedules together and come back to this, but despite it all, we're still going forward. So there's got to be something said for sheer will and determination.
Right.
And Jim, you and I have been together for a while, like a long while, and we're down to like 5 main topics of the case itself and the trial and how this happened. I mean, we started off with how everybody knew each other, met, where they came from, how the allegations came about through the motives of family, money, and sex. You know,
right.
We've seen state evidence proving my innocence. I mean, we covered a lot of ground. And the one topic I wanted to get to tonight is a short topic. And so everybody knows Jim, and the people that are, the people that are listening. Jim and I have been discussing a case that erupted out of the Medina County Court of Common Pleas, State of Ohio versus Frank P. Wood. That's me, the innocent guy, still stuck here. And the case number is 05CR0365. Jim, right now I'm going to read a...
This call is originating from an Ohio correctional facility and may be recorded and monitored.
Jim, I'm going to be reading just a couple pages here, pages 322 through, I think, 326 from my book, A Blueprint for Wrongful Imprisonment, which people can download for free from my website, www.freefrankpwood.com, and they can keep up with my Facebook postings at Free Frank P. Wood at Facebook. Jim, we've seen direct evidence regarding the felony one. One, medically, the actual rape never happened. Two, that case was closed and terminated by several times by multiple state agencies. And three, the girl testified she was with her legal guardian father, Scott Sadowski, in Put-in-Bay and not at Frank Wood's house. What more, this poor girl could not even identify me as a perpetrator. And she also testified that she was not afraid of me. There's a reason for that. Now, then, Jim, there was the felony 3. The one where the girl miraculously twice could not recall being at a crime scene with me. Okay? That was the felony 3 GSI or gross sexual imposition. Now, and Judge Collier admitted on record, what I'm hearing her say is, no, it didn't happen. And then Prosecutor Eisenhower on record made a pact with this witness to put her back on the stand, violating federal law. With that said, Jim, tonight I want to discuss a Criminal Rule 29 motion for acquittal.
Okay.
Now, after the state rested its case, my lead lawyer was F. Harrison Green out of Cincinnati, and he requested a Criminal Rule 29 on both allegations. Judge Collier, who tried this case, so to speak, refused to dismiss the charges. He did so at 4 swift and well-practiced steps. First, he declared by operation of law, and this is right out of the transcripts, page 463, Exhibit 45 in my book. He said, when a court makes a determination on a Rule 29 motion, the court has to view the facts of the case most strongly against the party making the motion. Pausing here for a moment, Jim. According to United States v. Johnson, a trial court is to view all evidence presented in a light favorable to the state. So this renders the presumption of innocence as fraudulent as a constitutionally fair trial. You're going to prison unless a smoking gun walks in the courtroom, you're done. They do this for profit and they make money at it. Now, getting back to it, Judge Collier said, that is to say, view the facts most strongly against the defendant in the case and make a determination as to whether or not there is any such evidence which, if believed by a reasonable juror, now I'm going to pause here for a minute. Remember, Judge Collier declared certain members of my jury to be cynical. And if you recall, he tampered with my jury when he begged that woman who was molested in her youth to do the trial. And he said, please do this for me. Ron Stanley's my witness. His affidavit to this is in my book. And so everybody can recall what I said in a previous recording. The jury transcripts, the voir dire, the selection, is missing. It's never been produced. Now, I'm going to keep going. The jury could come to the conclusion that the defendant committed this offense. Okay? Now, I'm going to go ahead here. And looking at felony 3 is his second step. He said, looking at the issue of gross sexual imposition, NKS, the court recalls the victim in the case saying that she did not remember going up to a room in Chippewa Lake with this defendant. Now, Jim, keep in mind, the crime scene is not mentioned in my indictment or my bill of particulars. And so the everyday guy out there knows, and lady, a bill of particulars must be presented because that is the actual charge you're facing in trial, the allegations you must defend and refute at all costs. Now, so he admits all this, okay? And he continued with, there was other supporting evidence supporting the prosecution that such an event occurred. Wait a minute. What evidence? First of all, he relied, so everybody knows,
This call is originating from an Ohio correctional facility and may be recorded and monitored.
Under the U.S. Sixth Amendment, I have the right to confront witnesses against me. Okay? Now, Dr. LaJour was a witness who interviewed this girl without my lawyer present. And if you recall, Jim, before trial, she walked her report into the judge's chambers. And he goes, oh, there's nothing exculpatory. How does he know? I knew these people. I lived with them. What were they hiding? Now, so he was relying on Dr. LaJour's testimony to sway the jury to convict me of this charge. And keep in mind, Dr. LaJour interviewed this girl with the state's theory of PERP as me in mind, and concluded that she suffered from adjustment disorder due to all the male figures in her life, people the doctor never interviewed. Now, with that said, recall that Dr. LaJour received that county contract from the Medina County Commissioners to receive public tax dollars, and this is the killer, to provide free counseling to sexually abused children in Medina County. Okay, I got the Medina County Commissioners meeting minutes published in my book on my website. That is violation of federal law. That is RICO, Racketeer Influence Corrupt Organizations. Okay, she changed her diagnosis. Once she got that county contract, I'm making this perfectly crystal, from sexual abuse, from adjustment disorder to sexual abuse. She got paid. Okay? What's more reliable, Jim? The witness's testimony or a hearsay witness's testimony? The victim.
Right.
Okay? I mean, plain and simple. Her. Nobody wanted to listen, and like I said before, nobody wanted to discuss Uncle Ryan, remember? Oh yeah. They didn't like that at all. Now, let's see here. And no, let's not forget Detective Kohler lied about the pictures during trial to sway the jury. So my lawyer and I, we got the pictures, and they're also published on my website. Yeah. Now, let's see here. Okay, then Judge Collier went with his third step. Again, he said, I think a reasonable juror could believe that offense occurred. That's transcript page 464. Wait a minute. A reasonable juror. Jim, there was not an ice cube's chance in the Sahara. Okay? They were gunning for a conviction. They tampered with my jury. They made the jury transcripts disappear. They wouldn't let Dr. Reed, the Attorney General's expert, testify on my behalf. And they were making sure they were securing a conviction.
Right.
Now, let's see here. Now, as to the alleged rape.
This call is originating from an Ohio correctional facility and may be recorded and monitored.
As to the actual felony one rape, here's the fourth step. Judge Collier said this, and I'm quoting it. I'm making that same determination based on the testimony of the victim in the case. Of course, she was in Clinton Bay and not at Frank Wood's house. The court believes that there is sufficient evidence for a reasonable jury to conclude that this offense may have occurred.
Right.
Wait a minute. Judge Collier is now doing what he calls vouching. He is vouching for the credibility of state witnesses on record. And this is important because when we get to the jury instructions in the next couple of phone calls, when we get back together, when you hear this, you're going to be stunned. Stunned. Now, let's see here. Now, Judge Collier, again here, acted in subsidium. That's in aid of the state. Okay? That's illegal. And if I recall, there were over 22 instances that I recorded in my book from the record. Okay? Now, Judge Collier committed what we call an abuse of power. And this is right out of Black's Law Dictionary. The misuse of improper exercise of one's authority, especially the exercise of a statutorily or otherwise duly conferred authority in a way that is tortious, unlawful, or outside its proper scope. Okay? Judge Collier acted willfully as he engaged his judicial powers for the sole tortious purpose of sending this innocent man to prison. He knew exactly what he was doing. They all did. And they did this knowing nothing was being recorded. That's the problem. And like I said before and posted not too long ago on my website, Facebook account, all criminal proceedings must, by law, be audio, video recorded. No excuses. None whatsoever. Because that is the only way to stop them from doing what they're doing. Under the 13th Amendment, Section 1, I am enslaved for profit. And this is how they did it. Now, Jim, so you know, this is the only topic I wanted to discuss tonight. Okay?
Okay.
Because I got everything broke down for what we're going to do here in the near future. Let me see if I got this right here. Yes. The next thing I want to get into, Jim, when we get back together, is the jury instructions, and I want...
You have 1 minute remaining.
We'll make that next Friday, same time.
Sure, and we'll get into the jury instructions and then closing arguments.
That sounds great, Frank.
Again, I thank you for this opportunity to be heard.
Thanks, Frank.
And next Friday, same time, I'll give you a call next week, too.
Okay. Bye-bye.
Thank you, Jim.
Bye.
Take care.
That's Frank P. Wood. He's at Richland Correctional Institution, folks. We'll be back next week. Have a safe weekend and enjoy yourself.